All right, we'll call this hearing to order. Good afternoon. Thanks to all of our witnesses for being here. Today, the committee will receive testimony from our witnesses on the following bills. S-279, the Tribal School Federal Insurance Parity Act. S-790, a bill to clarify certain provisions of public law. 103-116, the Catawba Indian Tribe of South Carolina Land Claims Settlement Act of 1993 and for other purposes. And S-832, a bill to nullify the supplemental treaty between the United States of America and the Confederated Tribes and Bands of Indians of Middle Oregon, concluded on November 15, 1865. On January 30, 2019, Senators Thune and Rounds introduced S-279, the Tribal School Federal Insurance Parity Act. Senators Udall, Heinrich, Barrasso, and Tester are co-sponsors. S-279 amends Section 409 of the Indian Healthcare Improvement Act and allows for tribal grant schools operating grants under the Tribally Controlled Schools Act of 1988 to be eligible for participation in the federal employee health benefits and federal employees group life insurance programs. According to the Office of Personnel Management, consultation with the Departments of the Interior and Health and Human Services, tribal grant schools are ineligible to receive coverage from the federal employee health benefits and the federal employee group life insurance programs without a change to the Indian Healthcare Improvement Act that explicitly includes schools operating grants under the Tribally Controlled Schools Act of 1988. However, BIE operated and BIE contract schools are eligible to receive coverage from the federal employee health benefits and the federal employees group life insurance programs, thus creating a disparity. Currently, there are 128 tribal grant schools in 23 states across the country, and staff from these schools that cannot receive benefits from the federal employee health benefits and the federal employee group life insurance programs. By not being able to access these programs, tribal grant schools are using education dollars to provide health insurance coverage to its employees. Allowing participation in these federal insurance programs will allow tribal grant schools to use education funds for recruiting and retaining educators and providing supplies and other needed resources. Senator Thune is unable to attend today's hearing, but has submitted a statement for the record that will be included. On March 13, 2019, Senator Graham introduced S-790. Senators Burr and Tillis have joined as co-sponsors. 26 years ago, Congress passed the Catawba Indian Tribe of South Carolina Land Claims Settlement Act of 1993. Under this law, the Catawba Tribe, in exchange for reservation lands, federal and state money payments, and other federal services, agreed to drop a land claim suit it had filed in federal court. This settlement act provided that the tribe would be subject to the laws of the state of South Carolina in regard to conducting gaming within the state. Through a series of court challenges, the state of South Carolina successfully asserted its rights under the Settlement Act to prohibit the tribe from conducting any gaming within its borders. S-790 will provide authority for the Secretary of the Interior to take land into trust on behalf of the tribe for the purpose of gaming in the bordering state of North Carolina. The bill explicitly details the parcel of land where gaming will take place and requires that the tribe conduct their gaming activities within the federal regulatory framework of the Indian Gaming Regulatory Act. Finally, the committee will hear testimony on S-832, a bill to nullify the supplemental treaty between the United States of America and the Confederated Tribes and Bands of Indians of Middle Oregon, concluded on November 15, 1865. On March 14, 2019, Senator Merkley introduced S-832. Senator Wyden joined as a co-sponsor. In 1855, the Warm Springs Tribe entered into a treaty with the federal government that ceded the tribe's territorial interest in the state of Oregon in exchange for consideration that included a reservation and monetary compensation. In 1865, the Superintendent of Indian Affairs for Oregon drafted a supplemental treaty which revised the tribe's rights under the original 1855 treaty. The supplemental treaty prohibited the rights of tribal members to hunt and fish on their own lands, as well as required tribal members to seek permission from the superintendent when they chose to leave the reservation. S-832 will nullify the supplemental 1865 treaty and leave the 1855 treaty as the only recognized and legal treaty between the United States and the Confederated Tribes and Bands of Indians of Middle Oregon. With that, I'll turn to Vice Chairman Udall for his opening statement.